But dealing with government corruption, the Jack Smith's documents case against President Trump was dismissed with prejudice this past week.
It's incredible how much happened last week. We were on the road together. We were there for 4 days. It feels like it was 4 months. It was Monday of last week, what I'm dubbing White Pill Monday. Trump survives an assassination attempt. He nominates J.D. Vance as VP, or appoints J.D. Vance as VP. And Judge Aileen Cannon out of Florida dismisses the documents case with basically, I'm lisping here, basically a scathing rebuke of Jack Smith, his appointment, and everything that he's done. Took the blueprint from Clarence Thomas's concurring separate opinion on the immunity. Said this is how kings and royalty work. They appoint their own private investigators to go after their political rivals. They create offices that they out of whole cloth, not offices that existed under law. They bypass any government scrutiny, congressional hearings, congressional approval, and they just prosecute their political rivals like Joe Biden did. In addition to, just basically facilitating their murder, he facilitates their lawfare murder by doing what Jack Smith did. She tosses the case. Choice words for Jack Smith. Elaborate, flesh it out, and tell us what impact it will have, if any, on the Judge Chutkan case, which presumably should get tossed for the exact same reason.
No doubt. In some other cases, there was because they brought cases against other defendants in that case, in the Trump case, that should also be dismissed in the as well. So first, I got to give a shout out to one of the lawyers we interviewed, former assistant U.S. attorney at the Justice Department, Jeffrey Clark, who the corrupt D.C. bar is trying to take out. The first person to notify me that this special counsel appointment was completely constitutionally bogus was Jeff Clark. Mm-hmm. And he was the one saying, we need to get this information to Trump's defense team. And he had already thought it through. He'd already analyzed it. He's a brilliant lawyer. It's an embarrassment of the DC bar that they're trying to disbar him for complete hogwash. I think we met Mike Davis at the Republican National Convention, had fun chatting it up with him. He apparently was enjoying those Wisconsin beers. And his expression communicated that appreciation. There are good beers there in Wisconsin. He's dead on accurate, and he ended up being very prescient. And it's thanks to his good legal work, and as far as I know, that this argument even got made in the way it got made. That Edwin Meese ended up joining in, that other people were getting. So he again deserves great credit for this critical work done on behalf of President Trump. The issue was twofold. The appointments clause to the Constitution and the apportionments clause, appropriations clause of the Constitution. The appointments clause says that any officer, principal or inferior, has to be nominated by the president and approved by the Senate. Congress can choose to allow other people to nominate inferior officers, but it has to specifically do so by legislative action. The goal was there had been so much abuse by the king, by the British king and by the British royals in how they appointed officials that they did not want to give carte blanche to the executive branch to appoint whomever they wanted. The executive branch had to get the involvement at some level of Congress for those appointments. If a principal officer, always their consent of the Senate. Inferior officer, also the approval of the Senate, unless Congress specifically said, hey, you can appoint this person or you can appoint this kind of official. The issue with the appropriations clause is that no money can be spent by the Treasury that Congress hasn't authorized to be spent for that precise purpose. The issue with Jack Smith is that he was a private citizen who had never been appointed by the president with the consent of the Senate, not for any level of office. The second problem was he was given a budget without any limitation. It was just spend whatever you want for as long as you want, even though Congress had never appropriated any funds for his office, for any investigation to be done. Credit to Marjorie Taylor Greene and others who have been raising this as a complaint. Credit to Thomas Massey, who also have been raising this as a complaint. And so what the Judge Cannon said is, okay, has Jack Smith is if he's a principal officer, he had to be appointed by the president with consent of the Senate. That never happened. So that means he didn't have any powers to act as a U.S. attorney in that instance. If he's an inferior officer, he also had to be appointed by the president with the consent of the Senate unless Congress created his office. And did Congress create his office? No, it didn't. So in fact, what the judge went through was their only excuse, for the most part, was an FBI statute. It was an FBI statute and a generic statute involving commissioning special counsel. So what it is when they reorganized the FBI and reorganized the Justice Department at different times throughout history. We didn't have a Justice Department until 1870, by the way. We might still be better off if it was gone. That's another story for another day. They reorganized it multiple times over the years. And when they did, they created logistical statutes to say, okay, when you have a special counsel, here's how you commission them, here's how you pay them, here's what oath they take, etc. He tried to take the commissioning paying statute and say that's actually an appointment statute, which of course by law it can't be under the Constitution. Not only that, Congress, when it wants to give you somebody appointment power, it uses the exact language of the Constitution. It mirrors it and quotes it. That isn't here. In fact, they use the past tense of the verb, a special counsel retained, or someone that's already been hired, because it's a logistic statute. She's like, a logistic statute can't confer appointment authority. So that meant he had no appointments authority. And then they took the FBI provision, right, that talks about how you can hire FBI agents to prosecute crimes, as saying, you know what? That means that the Attorney General doesn't have to get the approval of the Senate or the nomination of the president for appointing anybody in the entire Justice Department. He can give all the power of the Justice Department to anyone he wants, anytime he wants, under this FBI statute. And she's like, well, first of all, ain't that putting a truck through what's the word? It's like something through a mouse hole. I mean, it's, a whole tanker ship through a mouse hole, whatever the language is. That comes from the case from about 20 years ago. She's like, Congress doesn't do that when it wants to give that degree of power to the Justice Department. And she said, it's clear that this, when you read the whole statute and the history and all the rest, it's referencing FBI agents, non-officer employees. It's not meaning give them the power of the Attorney General of the United States to go around and do whatever they want. And then, of course, the appropriations clause is an additional problem. She says, I don't even need to get there, but if I did get there, I would say his appropriations clearly violates the appropriations clause because he's never been given this money by Congress ever. They're just spending ceaseless money they didn't have authority to. And then the only question is, what's the remedy? Well, if you have someone who does not have the constitutional authority to be a U.S. attorney, it's like the only remedy is dismissal of the indictment, period, because the indictment was remember we were talking about this a couple of weeks ago, where other people were predicting somebody else would come in and try the case. Yep. I was like, no, the only remedy is dismissal because he didn't have authority to go to the grand jury in the first place. He didn't have the authority to gather the evidence in the first place. He didn't have the authority to seek an indictment in the first place. He didn't have the authority to give people sweetheart deals that led them to make up stories against President Trump in the first place. Judge, to her credit, came to the exact same conclusion. Said dismissal is the only remedy for this severe constitutional breach. Great ruling. Now Smith is appealing it up to the 11th Circuit. Again, I think all of this lawlessly because he's not a U.S. attorney. Be like me pretending I'm U.S. attorney and just filing an appeal with somebody. I don't think he has the authority to do so. But putting that aside, you're right as to the D.C. judge. If Jack Smith doesn't have the constitutional authority, he doesn't have the constitutional authority. So she's going to have to go in and pretend the statute means the exact opposite of what Judge Cannon concluded, which it wouldn't surprise me for this corrupt judge in D.C. to try to do. But that will in turn get appealed. Ultimately, if there's a split between the circuits, it's going to go to the Supreme Court, and the Supreme Court's going to say Justice Thomas was right because the plain language of the law reads in the exact way that Trump's defense lawyer said it did. Thanks to the great argument of Jeffrey Clark.
What was the relevance of, or at least the coincidence? Clarence Thomas oversees the circuit from which this would come to him by way of appeal. 11th Circuit,
yeah. Yeah, so, but what case he would oversee? But there's no great consequence of that because typically what happens is those Supreme Court justices refer the whole issue to the entire court. It just means if the 11th Circuit were to overturn the district court, I don't know how they plausibly can. I mean, you read through her decision. There's no weakness. I mean, you have to conclude that the Attorney General, that Congress in the statute authorizing the creation of the FBI intended to allow all U.S. attorneys to be nominated, to be chosen by the Attorney General without approval of the President or the Senate. No one has ever interpreted the FBI Act that way. By the way, if you want to hush-hush on the creation of the FBI, you can go to vivabarneslaw.locals.com and figure out the corrupt history of its very origins. But even putting that aside, ever since then, no one has interpreted this statute to mean that. So they're going to have to go against almost a century of legal history. And in most of the special counsels that have been chosen, she goes through, she says, almost none of them have ever cited this statute as their authority. The only other statute is the commissioning statute. And it's obvious that's not an appointment statute. And again, you'd have to butcher the legal history. The legislative history of the statute itself says, by the way, this commissioning statute is not an appointment statute. I mean, they would have to lie at so many levels to overturn her that I think the federal cases against Trump are DOA.
It's federal in Florida. It's federal in D.C. So what is the rule? This is persuasive but not binding coming out of Florida as relates in D.C.
Yes.
And if the 11th Circuit comes down and affirms it, does it become binding in D.C.?
No.
All right. So it takes the Supreme Court to adjudicate on this for it to be binding in D.C.
Correct.
Okay. So might be some time still. But so what do we expect to see out of DC then? Presumably this is the next, they make the exact same motion.
The DC judge. The
Okay.
DC judge is smart. She'll be like the New York judge who will use the excuse to get out of all this trouble. Remember, the goal was to convict Trump in the court of public opinion, get a conviction, damage him. They already realized that hasn't worked. That has backfired badly. So but I think this DC judge is such a political hack, you can't trust or rely on her to follow the law. Then the question is, will the DC Court of Appeals try to make a mockery of itself one more time, show what a political partisan hack court it is, and show why the DC court system should be entirely abolished by Congress by refusing to recognize the plain language of the law as to both the appointment clause and the appropriations clause, both of which independently prove why Jack Smith never had the constitutional authority to do what he has done in this case.